Our next case is Patarick with Patarick. Each party will have 15 minutes to present the argument. The council may reserve 5 minutes for rebuttal. How long would you like to reserve?
I would like to reserve 5 minutes, Your Honor.
Very good. Because we have no clock, if we look at the time up here, I will try to let you know when about a minute is left in your time. And then we'll let, when your time is up, if you keep talking, the court time will just come up with rebuttal time at that point. And I'll try to do the same for you when there's about a minute left in your time, counsel.
Thank you, Your Honor.
The arguments are being recorded, so when you come up, please, if you would, introduce yourself. Please stay behind the podium, because visually as well as audio recording you, and then we'll also be able to pick you up the microphone when you're back. I don't know there's any particular need in this case to refer any child or victim in this case, but if you would, please use initials or something rather than the child's name. With that, the court has read your argument, and ready to proceed, ready to brief, and ready to proceed whenever you are.
Thank you. Thank you, Your Honors. May it please the court, my name is Kelly Lorain, counsel for the appellant Felicia Patarick, and I will, as I said, try and reserve 5 minutes for rebuttal. Your Honors, the issues before this court are relatively simple in that the underlying matter was settled and resolved by an in-court agreement and memorandum of understanding by the parties Felicia and Nicole in their divorce proceedings. The issues before you is that the trial court, in adopting that in-court agreement and memorandum of understanding, issued a judgment entry of divorce that was neither agreed upon and exceeded the terms of the in-court agreement and memorandum of understanding. The critical issue before you, one of 4 that we present for your review, is that the appellee was granted rights in excess of the agreement, outside the scope of the memorandum of understanding, and outside the in-court agreement and the terms therein. The issues as to parenting, Your Honors, are the critical issue in this appeal, because what was settled and resolved before the trial court was that the appellee waived all rights and claims for an allocation of parental rights and responsibilities. This issue arises out of a same-sex marriage where the issue was thoroughly briefed before the trial court, it was argued before the trial court judge, and given the arguments and limited testimony that was presented, the parties entered into a complete and global resolution of all issues. That resolution of issues was reduced into writing via a memorandum of understanding, and then was subsequently submitted to the court as proposed judgment entries. Both the appellant and appellee submitted their own proposals. The memorandum of understanding, however, and the in-court agreement were agreed to by the parties, and the settlement terms therein are binding on the trial court.
Well,
Under
counsel, let me stop you there, because that's one of my first questions. It's not binding on a trial court if the memorandum of understanding contains something that is illegal, right? Or that's not within the power of the court to order.
If you're referring to the jurisdictional issues, I would agree with you, Your Honors, and that is one of our fellow points.
No, I'm actually referring to the fact that one of the arguments here is pertaining, I think, to the matter of the child support, right?
Correct.
And how does the trial court order child support for a child that's not the biological child of a parent and is our alleged parent, or asserting some rights? I guess I should say the obligor. And they have waived any allocation of parental rights. How can a court order somebody that basically, under the law, looks like a stranger to the proceedings to pay child support?
Because that was per agreement, Your Honor. So,
But that's my whole point.
oh, yes. So
Yes,
that is,
can a court order something that court is not legally permitted to do just because you have an agreement? I think the answer is no, right?
I would disagree. I think the court does have the jurisdiction to issue that order.
Even if it's not legal?
I don't believe it is illegal, as you set forth, Your Honor. On that issue, I would set forth the appellee has not challenged the child support award. The only terms as to the child support award that have been challenged, I believe, are the deviation factors as set forth in the guidelines.
I thought one of the whole points was that this, the order that the court adopted did not also include that he would be, or she would be waiving her parental rights.
Correct. So, yes, there are the 2 separate issues.
So my point with that is, maybe the trial court did that because the trial court put into effect a part of the agreement that she was gonna be responsible for child support. And so those two are kind of conflicting in my mind. I could be wrong, but they're kind of conflicting, that if you don't have any rights to the child, you've waived complete rights, you're not a parent, but yet you're ordered to pay child support. And so the court then didn't put it in about waiving the rights.
Your Honor, I would refer back to 3109.051. The appellee was afforded companionship and visitation time with the child. Under the memorandum of understanding, it was a stair-step schedule, and I believe under that statute and the visitation time that she has, the court has the jurisdiction to issue that child support award. I believe under 3119, the trial court has the ability and the jurisdiction to issue that child support award, especially pursuant to the parties' agreement. And I would further assert that it's been waived, if any issue is there, by the appellee, because that was not challenged on the appeal nor in her brief.
Thank you for your answer.
Thank you, Your Honor. As referring back to the allocation of parental rights, as you referenced, Your Honor, the issue is that under Santa Mauro, the son's property management, which was issued by this court in 2019, the trial court's judgment entry of divorce has to be consistent with the terms of the settlement agreement. The appellee attempts to distort that issue by changing the terms of the underlying agreement to try and justify the trial court's order. The memorandum of understanding sets forth that the appellant, Ms. Patarick, will be the sole parent of the minor child, and that the appellee will be granted companionship and visitation under the statute pursuant to that agreed upon schedule, but it did not set forth any means for the appellee to ever return to the court to somehow modify the allocation of parental rights. That's the key factor here that we're challenging, is because the way we read the judgment entry is that it allows the appellee to return to the court at a subsequent point in time and somehow reassert a claim for parental rights that were waived fully and completely in that memorandum of understanding and in the in-court agreement. Your Honors.
But in that regard, it seemed to me, in this particular instance, you're the party saying, leave that as language to the MOU that wasn't there in the first place.
That was part of the in-court agreement, Your Honor. That the language that is there is necessary for 310904 to actually waive that claim. The memorandum.
So when you say part of the in-court agreement, that's something read on the record, it's not included in the MOU, or is it somehow included in the MOU?
It was
this language you want to adopt.
I'm sorry, Your Honor, I didn't mean to interrupt. The language that we were pushing to adopt, that the appellee does not have any parental rights, was in the memorandum of understanding when it was written as the appellant shall be the sole parent. The issue with being the sole parent is that the trial court has to find that the appellee does not have those rights. Otherwise, those rights could be reasserted at a future point. So it's, I think I would describe it as a distinction without a difference, as the way I think you're trying to state it, Your Honor. And I don't think that that would defeat the appellant's claims on the appeal, because we're trying to preserve the settlement agreement into the future.
Counsel?
Yes, Your Honor.
I'd just like to just break it down a little bit more. The concerning parental rights in custody, the judgment entry, didn't it say, pursuant to the parties' memorandum of understanding, Felicia shall be the sole parent of minor child SP born on September 1st, 2018, and is designated residential parent and legal custodian of the minor child. And the MOU said, Felicia Patarick shall be the sole parent of SP and is designated as the residential parent and legal custodian of the minor child. Is that accurate?
That is correct, Your Honor.
Okay, and then the other issue that you just mentioned, you argue that the trial, if I understand your argument right, the trial court's judgment entry should also state the defendant, Nicole Patarick, does not maintain any parental rights and or responsibilities concerning the minor child. But this language, to my colleague's question, wasn't in the MOU. Was it signed by both parties and agreed to by both parties on the record?
That language, no, was not in the memorandum, Your Honor, because the memorandum did not contain findings of the trial court. I think that's the difference in where our claims lie, is the trial court, we suggested, should make a finding of that, because the parties couldn't agree to that finding. The court has to make that finding. If that answers your question, I'm sorry, I don't.
Sure.
Thank you.
So I'm confused now.
Of course, ma'am. I'm sorry. I apologize if I've created
Just so you know, we're about a minute left in your time.
Okay.
I do appreciate that, Your Honor.
Okay, so the fact, the waiver of parental rights was not included in the memorandum of understanding.
I believe that the memorandum of understanding where it says that the appellant shall be the sole parent is the waiver of
You're
rights
saying
by
that's
the appellant.
implicitly including that.
Correct, and we request the trial court make the express finding
Thank you.
in support of that agreement.
I got you now.
So it would be like in comparison to a shared parenting plan, if you don't in there say it's in the best interest of the child, when the court does their journal entry, they must say this is the finding they must make within the best interest.
Correct.
And you're comparing it to that in essence.
Correct. We assert that the trial court had to make the finding, otherwise without that finding, the appellee could come back and say, well, she's the sole parent, or residential parent, but that's always modifiable under 310904.
Well, unless you have residual rights too, right?
I'm sorry, you're not in here.
If you are a sole parent, when you are given custody, primary custody, and you still have residual rights for the other parent. And like you said, one of them is, going back to court or whatever,
Correct.
but that's fine. You're out of time, so.
You can answer Judge Carr's question and then you're out of time with that.
I appreciate, can you restate the question? Or
No, I'm just trying to figure out legally how this all is constituted, that's all.
Okay.
I'm fine, go ahead.
Do you want to continue or save the rest of your
No,
time?
I'll save the rest of my time for rebuttal, Your Honor, I appreciate it.
Good morning, Your Honors. My name is T. Natus. May it please the court, I'm here on behalf of the respondent, Nicole Patarick, to address the court on this issue. The core of this issue is a claim that the lower court abused its discretion when it chose to use a judgment entry other than the one submitted by the opposing party. However, in its brief and in their oral arguments, opposing counsel provided you no facts which support that the lower court abused its discretion. I will give you a brief background of the facts leading up to this case, and then I will address the issues as it relates to what was in the judgment entry and what opposing counsel has asserted here. Facts and background here in the case is that the settlement primarily came down to the fact that my client wanted to have the ability to continue to see her child and be in her child's life, even if just in the periphery. Under no circumstances would she have voluntarily given up all parental rights and responsibilities, and nowhere in the memorandum of understanding or on the record did she waive all parental rights and responsibilities. There was a memorandum of understanding that was read into the record, signed and agreed on by both parties.
I guess I'm taking Judge, and I don't mean to interrupt early, but I'm taking Judge Carr's question. This whole agreement where it says the one person is the sole parent.
Yes.
Is to me indicating the other person isn't a parent. If there's a sole parent, there aren't two parents. I appreciate she said she didn't want to waive her parental rights, and certainly she has the right to visitation, all that kind of companionship. But it seemed to me this memorandum of understanding was saying she's not a parent. And that's because of Ohio statutes and everything else. It's a whole different question we're not going to get into today. But we're stuck with kind of trying to fit a round peg into a square hole that makes it very difficult here, unfortunately, for us to deal with these circumstances. So, and technically, to me, when you say sole parent, she is in fact the sole parent. The other person is not a parent.
Your Honor,
But that rights under the agreement based upon what's been entered into.
to, I guess, briefly answer your question and respond. The memorandum of understanding did say the word sole parent. Later in that memorandum of understanding, it clearly stated that Nicole pays child support. The only people that pay child support are parents. It also stated that Nicole will have access to the child's medical records and educational records. Other than legal guardians and custodians, only parents have access to those things. So although the words did say sole parent, it wasn't sole parent and waiving all rights and responsibilities, but as we understood it, sole custodial parents.
Well, it's stuck with a de facto du jure kind of situation. The fact of the matter is this is parents. Both these people were parents. The child knows both these people are parents.
Yes,
We're
sir.
stuck with trying to make this work under the law we have that is somewhat antiquated as far as that goes, and trying to do those things, which I appreciate your attempt to do and have with you.
Yes, Your Honor.
But you feel that obviously the things they were looking to add was in addition to the MOU and not part of the MOU.
Yes, Your Honor. Very basically and briefly, is the case law is very, very clear on this. In fact, they were quoting Santamaro, and we would also like to quote Santamaro and say exactly that. Adding additional terms to an agreement, as the opposing counsel tried to do, that would be an abuse of discretion, and therefore, it shouldn't be allowed. In this particular case, we talked a little bit about all of the issues at this point, but really the bottom line here is that the court, the lower court, has the ultimate discretion to enter in a judgment entry. And they could have taken ours, they could have taken theirs, they could have written their own. But at the end of the day, the lower court took a judgment entry that was aligned with the terms of the MOU, and that is what was entered into the record.
And since Mara says in essence they're abuse their discretion if they add or change that language, and in your case you're saying at least as of this first issue, it's not a modification or addition to keep it as it was actually.
Yes, Your Honor.
As far as the issue of the payment to counsel that had a date certain of 30 days from the agreement or whatever it was, and then the court, or the MOU, and then the court entering the final entry said 30 days from the entry. Is that a change under, or that permissible understanding?
Your Honor, I believe it is, but ultimately I think this issue is moot because the payment's already been made.
And that was unclear from the record, so payment's been made and accepted by the other party.
The payment has been made and accepted by the other party. Other issues that were brought up by opposing counsel was returning the Social Security card. That is also moot as that has been already completed. Another moot issue that was brought up by opposing counsel in their brief had to do with the side agreement. There's a whole long argument there, but here again, it's moot. The agreement has been signed. It is by all parties included. So none of that really has any bearing on this. So even if it were to be sent back to the lower court, these issues have already been resolved.
Counsel, it's interesting you say that because in the reply brief, the appellant alleges that the Social Security card was not returned that it's not moved. So how are we supposed to know now?
It is my understanding that the Social Security card
That's
is
fine.
moved.
I'm just asking the question. Do you understand that that was in the brief that they had denied that?
I do not remember reading that in the brief, Your Honor.
All right, that's fine.
Apologize.
Again, we'll look at everything.
One other issue that I wanted to address from the appellant's brief is that the petitioner was arguing that the trial court erred when it modified the child support payment. Here again, petitioner and respondent both signed the agreement in court that clearly stated that the respondent would be paying $750 per month for the child support. There's nothing here that we were trying to add or remove in terms of the judgment entry, and the judgment entry that was written was directly aligned with the MOU.
And that the MOU simply was a deviation based on agreement. There weren't any reasons for the deviation. It was on the MOU, as I recall.
Correct. Nothing was imputed for income. If anything, the deviation was upward, and my client is paying a premium here.
I'm assuming there was a hearing when this was, at least if not read on the record, the parties acknowledged that they signed the MOU at that point in time and they understood it.
Yes, Your Honor.
Was there any time at that hearing where there was any additions to the MOU that the parties agreed to on the record? Like, we agree we're deviating because A, B, C. Do you recall?
I do not recall that being read into the record. I believe the MOU was read into the record word for word.
Is that hearing in the transcript, that hearing where the MOU was done?
Yes, Your Honor.
Thank you.
So, just to summarize, the lower court has ultimate discretion with their judgment entries. There were no additional terms that were added into the judgment entry outside of what was agreed upon in court with the MOU. Lower court did not abuse their discretion, so therefore we are asking that this court leave that decision undisturbed. Thank you.
Thank you. Counsel, if you would start, would you kindly address the issue of notice?
I would, Your Honor. Give me 1 second. I appreciate it. Thank you, Your Honors. As far as the attorney's fees payment goes, we will agree that is moved. That payment was made. That was made prior to the briefing, and I believe that was during the pre-mediation stage. As far as the Social Security card, Your Honor, I do not have confirmation that that issue is moved. As we set forth in the reply brief, we did allege that that had not been complied with yet at that time. If it has been complied with since then, I don't have confirmation of it, and it's not in the record. So as far as the timing goes, we would just assert that by failing to put a deadline on it, it remains unenforceable. Briefly,
Has the agreement been signed, the side agreement, to your knowledge?
the side agreement was also signed. That was part of the payment for the attorney's fees in pre-mediation.
Would you agree that make that issue moot at this point in time?
I do not, Your Honor, as to the jurisdiction, only because the trial court, rather than just adopting the memorandum of understanding, actually took that language out of that agreement and made it an enforceable provision in a domestic relations court judgment entry. So the issue as to that jurisdiction is that the trial court in a domestic relations case does not have the jurisdiction to enforce an agreement in probate court. The memorandum of understanding expressly states that pursuant to that agreement, any type of visitation, proceedings, or action to be filed by the appellee would be filed in the applicable probate court. If my client were ever to remarry or the child to be adopted at some point in time, that's outside of the trial court's jurisdiction under Ohio Revised Code 23, I believe, 0103, or 2309.03, I apologize, Your Honors. Under the statute, the trial court in this case can't enforce a probate proceeding. That's outside of the grant of jurisdiction by the General Assembly and cannot be enforced, so we're contesting that that issue is not moot. As to the parenting, just briefly, Your Honor, I agree that it is an abuse of discretion standard. However, both the Ohio Supreme Court and district courts have held that no trial court has the discretion to commit an error of law. So we assert by violating Santomaro in this court's precedent, that does constitute an abuse of discretion, and it's more than just the arbitrary and capricious standard under Blakemore. Your Honor, just briefly to touch on some of the points raised by counsel, the child support agreement under the memorandum of understanding, I agree, sets forth that pursuant to the parties' agreement as set forth in the memorandum, the appellee will be paying $750 a month plus the 2% processing fee. However, the memorandum of understanding does not identify any of the deviation factors that the court would have to make in issuing that deviation under 3119.22 and 23. Part of the proposed entry that was submitted to the trial court was that it took those factors as set forth in the statute and applied them. There was a disparity of income and agreement of the parties. The appellant has the majority of parenting time. So pursuant to those factors, that supports the deviation. If the trial court fails to set forth any type of justification for a deviation, the appellate court and the Ohio law sets forth that it would be reversed, because if the appellate court can't justify or determine what the trial court's reasoning is, that's an abuse of discretion.
Did the trial court's order say it was deviated by agreement of the parties, or did it not say anything about deviation? My recollection was it said deviated by agreement.
Correct. I believe it did add one of the factors listed, but it didn't apply the other applicable factors. Your Honor, we're not contesting the amount of support or the trial court's ability to issue the support, just the findings of fact that are necessary to justify that deviation. As far as the side agreement goes, Your Honor, I agree that it was signed in the pre-mediation. It comes down to a competition of jurisdiction between the domestic relations court and probate court, and as set forth in the appellant's brief and reply brief, the trial court lacks the subject matter jurisdiction to adopt that agreement, enforce that agreement, or do anything other than acknowledge that it was part of the memorandum of understanding and can be enforced separately by the appellee in a separate proceeding. If there's no further questions, I will rest on the arguments and citations in the briefs, and I thank the court for its time.
Thank you. See no questions. The court will take the matter under advisement and issue a decision in due course. When that decision is released, we mail you by the clerk of court, or maybe counsel by the clerk of court, and then will be available on the High Supreme Court's website. With that, I want to thank both for returning for their presentation.